Welcome to the Privacy Enhancing Technologies and AI panel. My name is Singh. I'm based at the University of Cambridge. I head up the Compliant and Accountable Systems Research Group, which is based in the Department of Computer Science and Technology, and I also co-chair the Trust and Technology Initiative, which is the sponsor of this panel. Just a quick overview of the initiative. The initiative aims to bring together and drive forward interdisciplinary research to explore the dynamics of trust and distrust regarding internet technology, society and power, to better inform trustworthy design and governance of next generation technology at the early R&D stages, and to promote informed, critical and engaging voices supporting individuals, communities and institutions, giving technologies increasing pervasiveness. Really what we're about is trying to facilitate collaboration across academia, industry, civil society, government and public around all sorts of topics that are being raised throughout this conference. So some contact details are shown on the slide. Please get in contact if you'd like to get involved, collaborate on projects, so on and so forth. Right, so this panel is on privacy enhancing technologies, or otherwise known as PETs, and AI. Essentially what we see is that data is the driver of much innovation underpinning analytics, machine learning, or AI if you prefer to call it that. Given the issues and sensitivities of data, there's been a whole range of various technical tools and approaches to help manage the concerns of these sensitivities of this data. PETs, or privacy enhancing technologies, is a collective term for technologies that aim to increase levels of privacy. It's technology that aims specifically at privacy concerns. Now, there are lots of different PETs out there, including, for example, that enables anonymity in communication networks, dealing with issues of surveillance, and so on and so forth. If you've heard of the Tor project, that's one example of a PET in that space. Here, what we wanted to focus on, however, is technology dealing with the sensitivities of data for machine learning, analytics, and so forth. So the panel will reflect on PETs in this context. We have a range of panelists representing tech and legal perspectives from academia, industry, and the policy world. So just before I hand over to them, I'd like to begin by giving some context to the nature and some types of privacy-enhancing technologies. And just a forewarning or a caveat, these categories and descriptions are overly simplistic, very high level, just to sort of give some sort of intuition about what we're talking about in PETs in this context. So one category of PETs, which you can describe, is called those that are data-oriented. These involve methods and means that focus on the issues regarding the actual data or data sets themselves. One that's quite well known in this space is differential privacy, where essentially it says that the results of an analysis should not give much more information on an individual than if they were not included in the data feeding that computation in the first place. So in effect, it can allow the discovery of patterns about groups in a data set while limiting the information that's revealed about particular individuals. How this works in practice might involve fuzzifying or adding noise to a data set that's released, or as the data is collected, or maybe changing the results of queries depending on what might have been revealed from previous queries. This noise or perturbation is measurable and tunable, sometimes referred to as the privacy budget or epsilon, which essentially relates to the privacy risks of that data release. Another example in this space is synthetic data. This involves generating a data set that represents the nature or statistical distribution of the real data itself, or how it performs in particular analytic scenarios. The idea is that you can use this synthetic data set, rather than the real data set with that personal information, to still perform the analytics, look for patterns, train machine learning models, etc. And this works because that generated data set is representative of that real data set with that raw personal data. So in short, these sorts of methods involve protecting the nature of the data itself. Another category of PET refers to as data sealing. This is essentially about enabling computation without actually necessarily seeing or having access to the underlying data itself. One emerging technique in this space is called homomorphic encryption. So if you have encrypted data, it's often said to be not legible in the sense that you have the data but you can actually see what the data represents and so forth. What homomorphic encryption enables you to do is to provide computation or offers computational methods that you can perform computation over that encrypted data itself without actually seeing what that encrypted data represents in plain text form. Another example in this space is trusted execution environments. These are essentially hardware-backed cryptographic mechanisms built into the CPU, built into hardware, for isolating data and compute from other software and services running on that system. This means you can essentially give encrypted data and code to a third party and have them run it for you without them being able to see what that computation entailed, what that data entailed, and so forth. So in other words, you can go to a third party, say, here's some data, here's some code, you did that computation for me, you get the results back, but you have some guarantees that they were not able to see what that code was, what that data was, and so forth. So you can imagine this is particularly interesting from a cloud service provider context, where providers could essentially offer the infrastructure enabling analytics and machine learning, but in a manner which they can't necessarily see the specific of what's going on under the hood. The final category I'd like to mention is those are more around architectural concerns. And this is essentially about structuring the computation or the distribution of data and so forth to help improve privacy. And typically this is through some sort of federation of data and or compute. One example in this space is secure multi-party computation. So you can imagine a number of organizations or parties holding data, and you want to do some computation across them. You can imagine maybe, I don't know, some government departments across different states and so forth. Well, secure multi-party computation enables essentially distributed computation, where a result can be computed across the data of a number of these parties, but without each party having to reveal the data they hold, nor the details of that contribution to that overall result that would be produced. What we also see increasingly is discussions of technical infrastructure that aim at helping reverse the current approach to analytics, where it's sort of data is centralized. You bring all data to a central place, you aggregate it, and then you do the analytics and processing. Edge computing, personal data stores, etc., you hear talked about a lot, essentially provide technical environments and infrastructure that enable data to be held locally, for example, on device, maybe representing data in this room, maybe some sort of virtual device holding all the information on me personally. So when some third party wants to do some computational analysis, essentially what it involves them sending the compute or code to these particular areas, to these particular devices, and the computation is done locally over that data. That is, that third party only receives back the results of the processing. They don't actually receive the data in and of itself. This is kind of interesting because it's then left revealing in terms of the raw data, but also provides a point of mediation if you're actually in control of that place where those devices holding the data are kept. And this sort of stuff ties into the ongoing work on federated learning, which essentially involves machine learning across devices or data stores in a manner that tries to account for privacy concerns, as opposed to that sort of first collecting all the data in one place and then doing the analytics or processing over that. And I'd just like to end with some personal reflections from a computer science researcher perspective. So computer science researchers, we look to engineer solutions for problems. And what we've seen from the discussion some of the PETs raise is that much of the focus is on confidentiality. Now this is rather unsurprising. PETs has a long history coming out of the computer science security domain, and confidentiality is a key pillar of security. But there's been less focus and discussion in the computer science community on other data protection concerns. Data protection by design, for example, can potentially hinder people exercising their rights, as some people on this room and on this panel have explored. Trade-offs become interesting. We increasingly hear a number of calls for various things to be done by design. For example, privacy by design, data protection by design, accountability by design, security by design, all these sorts of things. Now more recently you hear about sustainability by design. How do we build systems to be more energy efficient so that they burn less energy, better for the environment and so forth? What's interesting is that a lot of the PETs just talked about and discussed are actually far more computationally expensive than traditional methods. They introduce overheads. So you've got all these sorts of inherent trade-offs in this space, not only amongst data protection concerns, but also broader societal concerns as well. So if we're talking about engineering things, we need to think how we balance these competing interests. More generally, we're well aware that there are a whole range of different tech society issues, and this audience knows better than any that tech can only help in some respects. Usually tech won't in and of itself be the answer. And for this, I think collaboration is key to help better align and focus engineering efforts towards areas that can have real impact. And so from the CS perspective, the discipline really needs to hear more from a range of different voices. So that being design and engineers is actually helpful, useful, and helps address the broader tech society concerns. So that was just like a brief overview of nature of some PETs to set up the discussion from the panel. I'll now pass over to each panelist who will give their perspectives before opening up to discussion in their traditional manner. To begin with, I'd like to introduce Guy Cohen. Guy is the head of policy at Privitar, a global enterprise privacy engineering software company which actually develops PETs. Guy's work looks at the intersection of privacy engineering, data protection law, and enterprise data strategy. And he'll talk a little bit to us about the role of PETs and their functions in business practices.
Great. Thank you, Jan. Thank you for having me here. Also, there's like 7 or 8 seats here. If anyone can't see or feels left out on the side, there's some great seats up front if you want to come and join now.
Please.
Do come on over. So yes, my name's Guy. I work for a company called Privitar. People heard of Privitar? Just quickly. Yeah, 2 people. Great. Oh no, 7 people. Okay, great. So yeah, we work in privacy engineering and we make privacy enhancing technologies. So I'm going to talk about a couple of things. First, some thoughts on how to categorize PETs in your head, because it's a weird set. and I think it's useful sometimes to have some structures to see how they're different, and how to think about them. I'll then talk about them, seeing as this is pets for AI, whatever that may mean. I'm going to talk a bit about where pets fit in the data analytics lifecycle, so when you might use which ones, and then a little bit about some of the constraints on pets. So data and privacy mean lots of different things. There's no technology that is good for every kind of data and every kind of use case to protect every kind of privacy goal. So certain pets are useful to achieve certain specific goals, and they're not very good at doing other things. So I'll give some examples of that. And I'll just say a little bit about the relationship between pets and data protection law, which essentially is they talk in different languages and there's a translation required. So first of all, some ways to think about pets. One, I think, important characterization, distinction rather, is pets for consumers versus pets for data controllers, right? So often when you hear about privacy enhancing technologies, someone will say, yeah, well, there's VPNs or there's Tor, or maybe that's combining a product with a concept again, or there's some plugin that's going to help you surf the web more safely or more privately. That's not what I'm talking about, right? So I'm talking about the privacy enhancing technologies that data controllers can use to limit the privacy risk associated with the collection, processing, and dissemination of data. So very different things. Sometimes the underlying technologies overlap, but often they don't, and certainly the products don't. So that's one distinction. I think another thing worth fleshing out is the distinction between private computation and private disclosure, right? So some pets aim to allow you to compute something in a way that the party that is doing the processing, or some other party, can't see what's happening in that processing. And other pets don't aim to do that. Instead, they aim to allow you to reveal certain information. Maybe it's a model, maybe it's statistics, but to do so in a way where you've limited what can be learned about any individual whose data went into doing that, into that model or that aggregate statistic or something like that. And so those are quite different things. So it's sometimes useful to think about, this is about computation, this is about disclosure. Okay, so where do some of these things fit? Oh, actually, one last thing on the other topic. Also, it's a weird set. So some things like differential privacy is a definition, right? It's a standard so that a technology might conform to. But it's not actually an algorithm or something like that. Whereas other pets, they are those cryptographic primitives. They're the building blocks, the algorithms themselves or something like that. And other pets might be architectural patterns. So they're not a specific algorithm or something, but they're a combination of different parties using algorithms or whatever it may be in different ways. So it's as a term, it covers a wide range of different things. Okay, so when centralizing data, there's a number of different things that can be considered that can allow privacy in that centralization process to gather data together. And some of those Jack just covered. So things like federated learning allow you to gather, to build a model without centralizing the data for that model. Now, there's lots of different ways in which one could do that, but one way is instead of submitting your raw data to the central party, you submit just the impact they would have had on the model. So just how they would have changed and updated that model. Or submit them to other parties in that system. So that's allowing you to prevent from centralizing all the data itself. Now again, that's helping you limit the information you're collecting, not necessarily limit the disclosure risk, because it may be that what's updated there still reveals something about the individual. So you may want to add other privacy protections as well as just dealing with that centralization issue. Other things in that space are things like secure multi-party computation or homomorphic encryption, where you may allow a group to process a function between them without actually revealing their underlying data. And so that can be, again, very useful, but it may be particular to certain scenarios. So again, a lot of these things are very use case specific. When you get to that central processing point, how do you make the processing itself more secure, more private? There's a range of things. De-identification, obviously, whether that's pseudonymization or something perhaps stronger, is widely used. That's a way of, when you're providing data for processing, limiting what can be learned about individuals. We also then again see homomorphic encryption being used in that space. This ability to process data without actually being able to see the underlying data itself. So you're processing the ciphertext and then just decrypting the result, the encrypted result, and just you can control which parties have access to that decrypted result. And then synthetic data, which we also see in that set there. And then finally, when you get to that disclosure, you may be disclosing, sometimes people are sharing a model, a machine learning model perhaps, or maybe they're sharing actual statistics, insights. And there we see differential privacy being used as a way of measuring how much information is being leaked about those statistics, and by measuring it, being able to control it. So giving a guarantee that anyone who sees those statistics can't learn more than a limit that's being controlled by the data controller. And things like privacy-preserving machine learning. So a lot of the time people think, well, statistics and models don't tell me anything, but actually you can attack models and statistics to reveal the underlying data that was used to train the model, or to, and Michael's written about this, or to work out the components of the statistics. So these techniques allow you to protect against those kind of attacks. So very briefly, I would say there's a lot of these technologies, you need to really think about the context that they're being used in and the use case. So synthetic data, for instance, we think is very good for developing and testing new systems, but can be problematic in other areas. So, for instance, synthetic data doesn't mean just one thing. There's lots of ways of making synthetic data. One way that's gaining traction is using GANs, a kind of machine learning model process to take raw data and create synthetic output. And that means that what's in the output, it may not be clear what is true of the real data or what the privacy risk is in that data. And so using that data for analytics can be problematic in terms of knowing actually what in this data can I trust, and is there a disclosure risk associated with using it. But again, it depends how you've generated that data. Again, federated learning, very good at dealing with that distributed system, not centralizing the data, but because you're not getting the data, you can't do certain checks on it. So you need to know that the data is encoded in the right way and there's high quality, and also control the structure that's going to be put into, because the model's going to expect it to look a certain way. So you need to control a lot of the infrastructure there. And differential privacy can be very helpful, but again, you're adding noise to the data, and sometimes for different use cases, that trade-off may not be palatable. So really helpful in some instances, in others less so, and also a lot of the work there is around the production of statistics, not row-level data. So I'll just close then on this reflection with data protection law. So as I mentioned, these technologies each have their own privacy properties. They each allow you to do something that protects some concept of privacy. That's not how data protection law is written, as you all know. Right? It's written in terms of principles and rights and responsibilities. And so they don't directly match up. And I would be very careful if someone says, this pet delivers this specific bit of law. It means you comply with X. Because actually, they're speaking slightly different languages, and a translation is required. And often there are other things that will dictate whether that does conform with a legal requirement or not. Specifically, often the parameters and the context within which they're being used. So for differential privacy, it's really a measure of information leakage. But it doesn't say what that amount of leakage should be. So the setting of epsilon becomes really important, right? And likewise with synthetic data, it's a synthetic copy of the data set, but how have you made it? Have you taken truths about individuals from the raw data and reproduced them in the output? Because if so, that may be highly disclosive. So it's not just looking at the technology, it's looking at the parameters of the technology and the use case it's being applied for, and that's really key. And I think one of the challenges we have is getting people to understand, who understand both the legal requirements and understand the technologies, to say what in a given instance allows this technology to achieve this legal goal. And I think there are mechanisms that we can explore to achieve that, but at the moment, I think it's a bit of a gap, and something that we need a bit more work on. But sorry, very high level view, and back to you, Jat.
Thanks a lot, Guy. In your experience, have you found that organisations are aware of the complexity of the PETS landscape and the relevance of context, etc., or do they just try and go and outsource those sorts of things?
So I would say with these things as ever, it really varies by industry and by organisation. So we work with a lot of large corporates, people like Citibank, HSBC, the NHS, and they have experts, privacy experts in those organisations who are very informed on some of these things. But financial services and health are sectors which care a lot about privacy in my experience, and are quite forward-thinking on it in lots of regards. I'm not sure about other industries. I'm also not sure about SMEs, where I imagine this must be much more challenging to access some of these technologies or to use them in a way that's fully understood.
Thanks a lot, Guy. So I'd now like to hand over to Yukiko Lorenzo, who's Senior Manager Counsel of the Privacy Team at Mastercard. She advises Mastercard's data analytics teams on privacy and data protection matters, including implementation of PETs and other controls. And she's actually standing in for Caroline Louveaux from Mastercard, who couldn't be here today, so thank you very much for that. And please talk to us a little bit about PETs in practice.
Thank you, Jad. And those of you who were expecting to see Caroline, apologies, but I'll do my best. I know it's after lunchtime, so I'll try to keep you entertained. As Guy said, there is a difference between what the law says and how we apply PET. And I'd like to kind of provide a slightly different angle to, yes, we do look at PET, we apply PET, so I support analytics team, so they do data perturbation, adding noise, one-way hashing. Yes, we've been already deploying that even before GDPR came into effect. But I just want to take you all through the kind of journey that Mastercard went through to make sure that we apply PETs, but also not just that, but create different governance structure and other controls to make sure that PETs alone is not what we do, but make sure that they are lived and then the effect is actually there. So before GDPR, as I mentioned, our analytics team had been applying various PETs, and we thought, oh, this is great. We think this is anonymized data. But then if you look at recital 26 of the GDPR, it talks about, well, whether the data is considered anonymized or not, you need to look at all means likely used by a controller, so your own organization, as well as another party. So just looking inward to say, okay, within the organization, we're quite good. We've got tokenization, encryption, all good, is not enough. We also thought that within the organization, we cannot destroy the underlying original data set. But then even though we beat up the data so bad, create another data set for analytics, the value of the data is really in the pattern and behavior. So if you look at the original data set and then the beat up data, you'll see the pattern, and it's actually not so difficult to link it back. So we thought that it's actually quite difficult to achieve true anonymization in-house. So we're like, well, what are we going to do? We're not really meeting recital 26. So we thought, okay, let's go outside of Mastercard, look to a third party, and see if we can have them do the anonymization if we can't do in-house. But then hold on. If the service provider is going to be acting as our data processor, we're still giving them instructions. So that means we will know what kind of anonymization techniques they might apply, and we might be able to reverse engineer. So then it kind of beats the purpose, right? So we're like, okay, that doesn't quite work. We're like, okay, well, what about we create a trust that do anonymization? That trust will act as a separate independent controller, so they do not take any instructions from the controller. So it's sort of kind of black box in the sense that how they do anonymization is not known. And then what if they actually apply analytics or apply scripts to create algorithm model segmentation and provide that back to us? So we thought, oh, that might work. So what we've done is we've established a trust called Truada. They're based in Dublin. They are a trust, so it's not a normal corporation, it's a trust. They're completely independent from Mastercard. We have no control over them. They have their own operations, CEO, their legal DPO, completely separate. And we don't know how they anonymize data, because we don't want to know, and we never give instructions to them. So we developed that, and it's been working well so far. So we provide data to them. They anonymize in a way that we don't know. Now, how it works is that we already prepare pseudonymized data, send the file to them. At that point, we delete the pseudonymized data set. Truada receives that data. They further process. We don't know what they do. They also delete the data set they received from us, so that we sever the link there, so that we reduce the risk. They apply various anonymization techniques, and then based on the scripts that we gave, they'll perform analytics. They will never, ever return any individual level data back to us. Because once again, even though they beat the data very badly, if it's at the individual level and there's a pattern, which we need to preserve for analytics purposes, the value in data is where we can see the pattern behavior. So if you beat up too badly, then there's no point doing analytics. But if the Gerard returns individual level data, then it's quite easy for us to then match it back again. So then it beats the purpose of having a third party doing this. So we have a strict controls in place in the trust document of trust that they won't do that. And then there's certain things that they do will trigger even consultation with the relevant data protection authority. So as you can see, we've quite gone far, not just applying PETs, but also the structure and governance around that to make sure that we meet the spirit of recital 26. So really taking into account all means reasonably likely to be used, available technologies. Is it possible for another third party who may be able to utilize this to see they can re-identify data? We did look at various angles to make sure that the process is robust and we can say comfortably that this is anonymized data. So it's a kind of interesting journey. I think we were quite creative in that, and it's been a lot of fun. Obviously, there's lots of things that go in it. For example, how do you validate the model when it's created by an anonymized data set, making sure that that model is actually providing the value. How do you do that? There's a lot of questions to be asked, but we think that this is a quite robust way of doing anonymization. This is one way, I guess, sort of PET, based approach, privacy by design. But I thought that it would be interesting to just kind of share with you the journey we went through. So.
Thank you very much. So it's interesting you're talking about, controls, other controls that might work to support PETs. In your experience, what was the sort of criteria to decide what aspects might be better dealt with technically, what aspects might be better dealt with outside through other mechanisms?
Yeah, well, we kind of mixed everything because I think ultimately technology in itself is not sufficient, in my opinion. So with the analytics team, so my colleagues who are data scientists, what we do is that in addition to this anonymization, we have what we call product brief. So each product has quite detailed what are the parameters, what are the cell size that's allowed, what use cases they allow. So there are various elements that we look into. We document that per product, and the product team needs to work within that confines. And we have many of those, so that actually the product team can look at that to see some inspiration and ideas so that they can create innovation, but within the safe zone, with privacy by design in mind, and then in a compliant manner.
Great, thanks a lot. So next up we have Michael Beale, who's a lecturer in digital rights and regulation at University College London's Faculty of Laws. And he's also a fellow of the Alan Turing Institute, researching at the intersection of emerging technologies, law, and human-computer interaction. He's actually very graciously standing in for Michèle Finck from MPI, who couldn't be here. And he'll talk a little bit about a legal and data protection perspective. Over to you.
Yeah, I'm not Michèle, but I'll do my best to provide some interesting tidbits. Probably not the same ones that she would have done, but let's. They're really useful to come after the previous three short talks because it introduces the field really nicely. And I think thinking about PETs for data analysis, I mean, AI is just obviously just a word that doesn't mean anything, but data analysis in particular, a core idea of many PETs, as Jat outlined, not all of them, is to bring analysis to data sets that could be held in a decentralized way. And the reason we might want to do this is because privacy is being seen in that context as confidentiality. That's really the way in which the word privacy is being defined at that moment. And the idea of centralizing data is then seen as a hazard you want to avoid. If you can get from A to C without going through B, which is the period of centralizing data, then that's seen as a good thing. So there's lots of proposals around how this could be used in practice. There are some deployed times when this has been used in practice. Some of them are really quite interesting. So Guy was talking about the opportunities in health a little bit, and that's, I think, a great opportunity to understand phenomena that are difficult to get at otherwise. There are some interesting initiatives in Boston, for example, around understanding gender pay gaps and gender ethnicity pay gaps from companies that are very unwilling to release position-level salary data and using multi-party computation to figure out things that we think are societally beneficial. So sometimes when we think about these aggregate properties, the C in the ABC, what we get to and what we want to get to is something where there's a clear public interest. I think that sounds quite good, and it can be quite clear. There are going to be some boundary cases, and we may need to think about what that is. But it becomes less clear when we think of ways in which privacy-enhancing technologies might be misused and misapplied and used in inappropriate manners. So, for example, here, we can take actually several examples already that have been discussed. Examples where the interest in the C, in the aggregate data, is primarily, it could be commercial, but commercial interests aren't necessarily bad interests here. But it could be commercial in a way that betrays reasonable expectations of a data subject. It could be manipulative. It could be a way of wielding informational power over individuals or groups. So I wanted let's talk about a couple of examples in the field briefly. One of them actually does involve a Mastercard, but hasn't been talked about yet. A collaboration, for example, between Mastercard and Google that is currently occurring using private set intersection and private set aggregation. The idea of this is that is relatively simple in its motivation. We've all got mobile phones in our pockets, and you will get targeted advertising on them occasionally. If it's targeted advertising for shoes or a book, you might click through and buy that service or product on a website that follows, in which case cookie tracking, other kinds of tracking, will register that as a conversion. That conversion will be communicated or at least used in the transaction between Google and the advertiser and the publisher in order to set prices for the way that advertising panned out. So that's all well and good, apart from the whole global pervasive tracking industry that underlies it. But where it's more difficult, at least for Google and the relative partners in these transactions, is when you're looking at adverts for, say, Coca-Cola or other sparkling drinks, or for large products like cars. In these cases, you're very unlikely to click through and buy. You're much more likely to either buy in a shop or maybe call up a dealership and ask to go for a test drive. And it's very hard to track back the causal relation between that advert and what happens in the end. So typically, a way to do this is to look at other sources of data, loyalty card data, financial data, but that becomes hugely problematic in terms of data linkage. So the idea here between Google and Mastercard and probably other providers that are being talked about, this is the only public side of it, is to link this data together. Link it together in a way that you return the aggregate result, so how much money was sold, how much money was involved in a certain ad campaign. So we ran a Coca-Cola ad campaign in the southwest of England, based on our estimates that people who saw this ad also spent X amount on Coca-Cola. For example, that's the kind of aggregate non-personal data that you'd want to get out at the end of this system. And that's the result of this. It's unclear whether it's a trial, how operational it is in practice. But you may say, okay, that seems like a commercially reasonable way to do this. It's a multi-party computation. The data is never shared between the two parties. Google doesn't hold Mastercard's data. Mastercard's not holding Google's data. But this calculation relies on the processing of the individual records of financial transactions and web browsing history in order to combine these two together. But you might then think, okay, well, I'm okay with that, but am I okay with, is that a free-for-all then? Am I okay with Google connecting with a health organization to say, I want to say how many people with a certain health condition have viewed this advert, or how many people have clicked through and bought something with a certain health condition, introducing other forms of data, even if the result is still non-personal data? Are we comfortable with creating a free-for-all to say, as long as it's confidential, as long as no individual's data is betrayed or revealed to another party, then it doesn't matter what you calculate with it? This is also exacerbated in practice, particularly around micro-targeting online, by the heavy prevalence of walled gardens and phones and operating systems, which undermines a core assumption of privacy-enhancing technologies of these kind, which is that individuals can, if they feel uncomfortable, opt out of any code running on their device. The cyber-libertarian model that underpins these pets that Jack was outlining is that individuals can say, well, I'm just not going to participate in that protocol, right? I'm not going to run this code on my device. That is not the case today. People do not have any idea, researchers barely have any idea, of the code that is running on Apple or Android operating systems. Android, there's some more research into. Apple, people frankly have no clue about what code is running on it in practice. So there's huge walled gardens. There's also generally conditionality of services. de facto making services conditional on data provision, even if that's not what the law permits. So these are considerable concerns. There's also huge interest in these technologies from intelligence agencies and other state bodies who see them as ways to increase surveillance in the sense of finding operational information about the world based on individual level personal data, while meeting different necessity tests and proportionality tests in a new way. For the focus on confidentiality in privacy-enhancing technologies does not deal with the core problem of group privacy and other factors of informational power that can be wielded in these situations. So say you had a large setup of multi-party computation, or you had different setups of systems that involve homomorphic encryption or other things between many, many entities that effectively allowed you to create a query machine where you can ask questions of this machine, quite arbitrary questions about which groups are congregating in a certain area, locations of activity at certain times of day, that all would traditionally require the centralization of individual level data. But you've learned to skip that step architecturally, as Jack was illustrating with the architectural discussion on the PowerPoint. And you can ask any question you want. If you're an authoritarian state, you can ask, I want to know where LGBT groups are congregating. That's not personal data. I can come back with a series of locations and say, well, it's fine because actually more than 10 people are at each of these locations regularly. It doesn't betray anything about any one individual. It's just a fact of the world. We're revealing facts of the world. You can see similar trajectories and desires in organizations like the World Food Programme, UN POP, and Global Pulse, who are looking for these kind of operational facts in the context of migration, borders, refugees, and so on. So the point I'm making here is it's quite straightforward, that this confusing privacy and confidentiality in some situations can be harmless, in other situations can be deadly. And we must not confuse them. We must make sure they are completely separate concepts in our minds when analyzing whether pets are good. And I think pets have a lot of promise. These pets, they can recreate some really coercive and nasty relationships, particularly with corporate sector organizations and online environments. There's a lot of promise for them, but they're being sold as a panacea. They're being sold as a legal opt-out. They are being sold as a way to increase experimentation. We already know how many experiments run constantly online, but this turns into something which is much more like research ethics. The question that universities have to grapple with, is this an okay research question to ask? When we're generating knowledge, is this a type of knowledge that we think is ethically correct to generate? Or is it a type of knowledge that we don't want to go and seek and generate? And privacy-enhanced technologies bring that question to the front, and companies have never had to deal with it very much. So lastly, not all hope is lost with legislation, thankfully, because it's quite clear in these situations that there are usually, when there's data sharing involved, situations of joint controllership. A very, very clever and subtle thing about European data protection law is that the definition of controller does not require you to even have ever seen any piece of personal data at any point. It's one of the only parts we have clarity on because the Court of Justice of the European Union have confirmed it 3 times in 3 separate judgments, Wirtschaftsakademie, Jehovah's Witnesses, and Fashion ID, where they've explicitly stood behind that point. These are joint controllers. In a relationship such as the one between Mastercard and Google, it is quite clear to me that if that's happening in a European context, they are joint controllers determining the means and purposes of processing. I'd also raise points that I would question whether the Truvata setup would be quite as separate as you think based on the Wirtschaftsakademie finding of providing scripts and benefiting from an aggregate result, even if that's never personal data is being transmitted. And I think there would be significant grey areas to explore in these setups. Now we can discuss what those grey areas and how they should fall and what the proportionate way to go about it is. But the challenge that remains in data protection is even though the controllership definition applies here, it's unclear how rights and obligations, such as access and objection, translate into a pet's world, because they tend to require you having more control over the code that runs on your devices or devices that are processing your data. Objection is the ability to opt out of a protocol, potentially, and at the moment, we don't have that ability built into operating systems, and it is not clear that operating systems are falling under the real purview of data protection law as clearly as we might like. Privacy by design doesn't apply to the creators of tools, it's applying to controllers, for example. So I'd leave it for there and move on to the rest of the panel, but there are important conditions before we say that pets are universally a good thing, and important legal considerations to look for in the future. Thanks.
Thanks very much, Michael. I think that reiterates the importance of context and so forth. I was wondering, Akiko, did you want to respond to it?
Sure. I just want to make sure that there's no misunderstanding that the Google Mastercard, that's just only in the US. We don't do that at all in Europe. So I just wanted to mention that. That wouldn't happen under my watch. Don't worry. So I just wanted to mention that.
And as I say, it's a balance whether we think that's okay or not, that thing, but the idea, the logic of that kind of collaboration requires scrutiny depending on the purposes of the collaboration.
I agree. And also, anyone can go to mastercard.com website. You can opt out from any analytics. So I just wanted to welcome all you to that as well. Thank you.
Okay, with that, we'll move on to our regulator perspective. So next to me, we've got Robert Riemann. Robert is a member of the IT Policy Unit of the European Data Protection Supervisor. He follows up on recent technological developments, including P2P, and supports inspections involving web and mobile technologies. So over to you, Robert.
Hello, I'm happy to be here and to speak about the role of the regulators, and in particular about demonstrating accountability and compliance towards regulators when complex systems such as pets or AI are involved. First, I would like to start with some general remarks that that may be expected to come to such a topic from a regulator. The EDPS, the European Data Protection Supervisor, of course, always highlighted the importance and the need to use these privacy-enhancing technologies. So we welcome that development, of course. And already in its preliminary opinion on privacy by design from May 2018, the EDPS recommends EU institutions to support an inventory and observatory of the state-of-the-art of privacy engineering and pets and their advancement. And this could all help us to have an overview what pets are around and could be used in practice by data controllers. Such a pet observatory and inventory would also be an important tool for the EDPS and other regulators to offer more regulatory guidance on how to use such pets in order to be compliant. The EDPS itself is also trying to do its part here and founded the Internet Privacy Engineering Network, in short IPEN, to bring together developers and data protection experts with a technical background from different areas and have then a discussion and promote the use of these privacy-enhancing technologies. But from a regulatory perspective, there are also some issues concerning pets because of the complexity. In order to understand it, I would like to invite you to a journey on inspection day. So let's now assume it's 2020 and the entire industry would have adopted all pets that you can imagine. And then I take you and invite you with me to come and visit a controller and find out if that controller is doing a good job and can demonstrate its compliance. And
apparently that controller is me.
Yeah, Jet volunteered to be a controller, so I think we can all applaud him for that job because it's a tough one.
Had bad counsel, anyway.
And the first step you would do is, of course, when you go on inspection, you have your inspection swag ready. So I have that here. So thank you so much, Jet, for opening the door to the regulator on data protection. And I would like to understand how your global company with, let's say, 50K employees manage HR data. So we have learned that you use already AI and that you have a lot of pets in place, for instance, to detect espionage in your company. And we would like to know what you can show us to demonstrate your compliance.
Well, we went to a major consulting firm and had them write up a DPIA for us.
Oh, this sounds very interesting. So, but I would be interested on which basis has this DPIA have been drafted. Is it just paperwork, or has there been more in order to come up with this DPIA?
We used a bunch of contracts, templates, and documentation that the software vendor provided us.
Okay, so now I have to understand if you really implement the data protection rules, and therefore it's not enough to just look at paper. So we would like to know at which point someone has actually assessed the actual processing, the code, or the setup of the server environment, the cloud servers, for instance. Have that been tested as well at some point?
Well, we didn't have access to that. That was the vendor's proprietary stuff. But the vendor's highly trusted. He's apparently used by pretty much all the companies in the field.
Huh. Yeah, so I wonder if there are any other means how you could demonstrate accountability.
Well, apparently we've got this device here that has like super administrator access, so you can go in and have a look around yourself.
Ah, okay. So I am supposed to look at your device and find out myself if I find any non-compliance. This is not how a data protection regulator sees and interprets the requirement to demonstrate compliance. But okay, don't you have a testing system for that we could use?
Well, we didn't have time to set one up. You said you were coming in 2 weeks, so, you know.
Okay, so I understand it is complicated when you're a global company with so many different places and such many cloud servers involved. That is, of course, not so easy to replicate for the purpose of an investigation. But let's turn to some positive aspects. Maybe, what about your pets? I hear you use pets. Can you explain me, when you use, for instance, differential privacy, how you have set up the parameters?
Well, the pets vendor came to us and gave this very nice flow chart of just follow this path, and then set epsilon to this value.
Okay, so of course I have never heard of this software vendor, and I don't know how their tool works. So I just know that normally there are a lot of assumptions done when you try to simplify a very complex software to the end of a flow chart. But okay, then maybe we are doing better with AI. So you use machine learning to determine the ideal profile of the best performing employee. And I have some doubts what does that mean to people's data? Is there maybe any bias involved in doing that that could lead to a kind of discrimination?
Oh, we were really careful by that. We stripped out the fields that had gender and race from the database. But if you really want to look, we give you access to our 50 terabyte database if you like.
Oh, this is so kind of you. I'm very happy that you did not print it out this for the regulator. And yeah, so I think we will come back to you and give you then our advice in writing. So thank you for that, Jed.
I hope it's only advice.
So you see there are a lot of open questions when we face AI and pets. So the question is, how can the controllers that decide to use these kind of technologies demonstrate their compliance? And of course we have to know that the people who work in the data protection authorities have to inspect all kinds of different complex systems. And it is unlikely that there's always an expert that has already used or assessed in depth this kind of particular tool that is put forward by that company. And when we have like algorithms like differential privacy, and I think Guy pointed this already out before, there are some parameters that you have to set, and it is not enough to just use differential privacy. You also have to configure it so it is effective. If you choose these parameters not in a good way, the entire system may be screwed and ineffective. And therefore, this is something very important. And the question is, how can people demonstrate that they have done this choice carefully in such a manner that people at the data protection authorities, or potentially also other authorities, could understand the reasoning and be reassured that the company is compliant. Then we already have mentioned the idea that the DPAs could also use technology. Why don't they have a tool that just runs on the controller's platform in order to find non-compliance? Of course, this looks attractive from when first thinking about it, but of course, this tool could be in itself a data protection problem. I don't know so many controllers who would be happy to have other people running their code in their system, and therefore, this may not be the best option either. So maybe there should be a copy then that is used in order to do these kind of things. But how can a copy of an entire complex system be carried out that involves lots of data and servers at different places of the world? And even if there would be a copy, how can a data protection authority understand that this is an actual copy that works in the same manner like the production system, so that they not investigate a system that has been optimized for compliance and works very differently from the production setup? So there are many questions to answer and many open questions still to find, I believe, and this is why we would like that all people who do research on privacy-enhancing technologies and people who like to use these privacy-enhancing technologies always think about the inspection day and ask themselves how could they explain in an intelligible manner their choices and their tools that they use to other parties, to auditors, to data protection authorities, in order to be held accountable for their processing.
Thanks a lot, Robert. So we'll start to move to discussion now. So one aspect that comes up quite a lot is the sort of multinational aspect to technology. Technology crosses boundaries and so on and so forth. So this can clearly affect compliance, and different regimes may lead to different business practices, different technologies being deployed. As we saw in the discussion just recently, what's happening in Mastercard Europe versus Mastercard US. Just want to ask the panel, how do we see the role of pets playing out over time as we see GDPR-like principles applied in other jurisdictions or other regions of the world increasingly being adopted, but with subtle differences, and also accounting for the sort of differences of what happens on the ground in different locales? How do we see that sort of area of pets playing out? Okay, go.
I can take that one. So even though I'm based here in Europe, I do work with other colleagues, including obviously in the US. And what I've seen, the trend is, for example, in Russia, South Africa, Brazil, they are actually starting looking at the level of kind of stricter anonymization standards. So they read Article 29, Working Parties Anonymization Techniques Opinion, and even Turkey, I think they interpret quite strictly in their anonymization regulation that you need to destroy your original data set to call it truly anonymized. So there are interesting different interpretation of how the pets should be applied, what will be considered sort of sufficiently protected. So I see divergence, but at the same time, Europe, EU seems to be setting some sort of kind of standard, and it's kind of spreading in other parts of the world. So it's kind of interesting to see that, and this probably discussion may be happening in other parts of the world now.
Okay. Just comment on that. So I think I sort of agree in some regards there. So I think one thing that's interesting is the definition of pseudonymization, right? So if you look at the CCPA, it's almost verbatim lifted from GDPR definition, and the Brazilian law is also very similar. So that concept seems to be more consistent. I think with anonymization or under CCPA de-identification, there is a convergence in one very important regard, which is the move to a risk threshold concept. That data is anonymous or de-identified when it's not reasonably likely. And there's one of the amendments to the CCPA that passed last year was this adding of the word reasonable again to the definition. So I think there's convergence there. Where I think there is still difference, and there is difference between the US and the UK, but also within Europe, between France and the UK and other countries, is how that risk threshold is assessed, the factors that are taken into consideration, and where that risk threshold is set. And that's something which I'd love to see more consolidation around. So I think this touches on some things that we've been talking. So one of the big questions is, can pets anonymize data and get you out of data protection law? And I think there's, in assessing that, we have the motivated intruder assessment in the UK. That's not clearly widely adopted in Europe. It seems to be referenced in some things, not in others. But again, that's an idea of you attack it with a certain strength attacker, and that's how you define what is reasonable. And there, I think you can look at a couple of different things. You can look at the output data set, and I think that's what some regulators do. They look at the output, and I think, and then in the UK, you look at the output in an environment. And by environment, I mean the context it was processed in, who had access, the physical considerations, all those things. And the risk of re-identification is a combination of those two. Now, that concept of output in an environment, I don't see as being yet globally adopted as a consideration. I do think is sensible. But then there's a third part, which is the mechanism and the process by which that data was created. And if you just look at the data environment, I think this is one of the things that you were sort of mentioning there, is, well, how do you know that's going to be reproduced over time, right? If you just see the data at one snapshot, how do you know that the next data set they create won't suddenly leak information? And so to have confidence that data is not anonymous at one point in time, and when we're talking about dynamic systems, obviously the data may be changing fairly rapidly, you need to have not just assess the output, I think, and the environment, but the mechanism by which it was created to understand for what conditions you could consider that process and that situation to produce anonymous information going forward. And I think that, again, is something which there is not yet regulatory alignment on globally, but would be great to see if we could move in that direction.
I've only got a brief point on this, which is that I think pets will place pets and other techniques like transfer learning, which are not really pets, but they have some relation, will place stress on the idea of data transfer, because what's really being transferred here is knowledge and optimization, informational power. There's been, in my view, a huge amount of lobbying to frame discussion by industry around centralized data being a challenge, inferences being a challenge, like the idea that there's a data thing that is moving around. But what's really happening is there are infrastructures of optimization that are being built in order to extract value from to construct and to extract value from large populaces of individuals. And you can do this without moving data around at all, and that's the PET's promise. And so it's not about data, it's not about inferences, and I think you should tell anyone who says it is, that's nonsense, or at least that may be the case for some minor businesses today, and it's maybe the case for and then maybe it'll stay there for them. It's maybe the case for the large ones that they are migrating away from, because I think when you war game out and you play out the future in this space, pets are a very, very important part of business models for the biggest companies going forwards. They're an important part of power consolidation. And so we do have to look carefully when we start inevitably to develop more international coordination mechanisms for data protection beyond the EDPB, to have some kind of global joint investigation, global approach, that we're not keeping the metaphor of data at the center. We are keeping understanding of processing, analysis, optimization, informational power as the core thing here, because the fundamental right to data protection is really a defense against informational power. It's not a defense against confidentiality issues or problems.
Great. Just before we open to the floor, did any one of the panel members want to raise a particular question or response to something they'd heard earlier?
I just wanted to quickly, a few small things. One, I very much agree the concept that something is private does not mean it's ethical. I think that's a good thing to keep in mind. Yes, sorry. Confidential in that sense does not mean it's ethical. There's lots of things that you don't want to hide. But also lots of things that become possible by doing that. And so I think this is why it's so important to look at the purpose and the use case when considering these things. Two, last year, the Royal Society published a report on privacy-enhancing technologies. If you want to find out more, it summarizes 5 pets and looks at some of the details on it. So I'd recommend checking out that if you wanted something a bit deeper. And third, just to echo something that was said earlier, yes, if you're looking at differential privacy and someone's saying something about it, like this is great, it's going to solve things, ask, how do you set epsilon and y? I think that should just be the first, as a heuristic, that should be the first question you ask. If you can't get a satisfying answer, yeah.
Thanks, Guy. I reiterate the Royal Society report. It's definitely a good read. Okay, so does anyone have any questions? I think we have a roaming mic. Okay, so you have to jump over each other to come up.
All right, thank you for the amazing session, especially for pointing out that this is on.
Maybe not.
Doesn't sound like it.
Especially for pointing out that pets are by no means a silver bullet to get anonymity, to get privacy and compliance. And I think even the scheme by Mastercard, really admirable how many work you put in. I think there's still an argument to be made that it may not be entirely compliant, and I think that sucks. So how can we, as a society, maybe improve the business case for privacy-enhancing technologies if there is not necessarily a legislative incentive?
I think that's a very good question, and I think it goes to the point where I made that, let's say if we do it is legally compliant, is it the right thing to do? And that's always we need to ask. That's why we always look at use cases. Who's going to be using that data? How it could be used. So that's beyond, obviously, legal compliance requirements. And that's really important for organizations, not just private sector, but public sector as well, and universities to really look at what could be down the line, how this can be used by another actor. And I think these thinking is actually essential, not just the privacy teams to consider, but with the stakeholders you work with. So it needs to come as a package. Pets alone are not good enough. I think it needs to have all the governance that comes with it.
I think the incentive in most cases should not be seeking to avoid data protection, but there is a significant incentive when you think of data protection as a multifaceted regime of which data minimization and relatedly privacy by design for data minimization in Article 25 are really core parts of it. So one way to say this is to challenge firms that are doing things in ridiculous, non-confidential ways and saying, well, that's not, you can do much, much better than this, and there are tools and practices that exist that are much better. And for regulators to start taking stock of what really good practice could be in that space for data minimization, and saying, no, we expect you to do this, otherwise data protection by design, fine of 2% of global turnover for breaching that. That doesn't mean that you escape data protection law and its fairness principles and other principles as well, but seeing it as it is necessary for compliance to keep up, but it's not going to say that the law doesn't apply, is another way of incentivizing. But regulators need to get wise and start to take action around data protection by design, which they are being unwilling to do because they are unwilling to define it.
Yeah. Okay. So,
All right, thank you so much.
can I just a couple of comments on that as well? So one quick one. I think we can work by actually trying to produce case studies or examples where pets have been used and getting them approved by a regulator to say, in this situation, we think this use of a pet meets this condition. Now, extrapolating from that is always going to be iffy because as the context changes, it may cease to be applicable. But I think that kind of thing and building a body of those towards codes of practice or codes of conduct to be certified against is one direction. So the second, for our clients and for others, it's not necessarily about achieving anonymization, as Michael said. It's often about unlocking use cases that otherwise weren't possible. When you look at the FCA tech sprint on pets last year, that was about saying we want to fight financial crime. To do that, we want to be able to identify bad actors without opening up sensitive transaction data sets. Can we use pets to stop money laundering and all the terrible things that goes to? And there's a great range of different things that we can do in that area. And the driver for that is not compliance with GDPR, it's opening up new possibilities that otherwise that weren't possible. I think that's where I'm excited about a lot of pets in financial services and in healthcare.
It's linked to the idea of necessity too. Is the data necessary for processing? And if you could argue it's not necessary because there are other ways to do it, that's an important legal lever.
So thank you very much for the interesting session. My name is Ala El-Momani. I'm from Ulm University. My question goes to Guy Cohen. Thank you for the nice and simplified overview over all the bits, almost all the bits. Yeah. So I do research actually in applied crypto and applied bits also as part of my research deals with that. And I came across an open question, at least for me. I don't know if you have any feedback on this. Is there any way to measure how much privacy do you gain by applying each bit? For example, at some point you figure out that there are, for example, 2 privacy-enhancing technologies that might be applicable in this situation. Intuitively, when you look into them, this provides better privacy for the consumer. Is there any way to provide more formal, let's say, numbers of privacy? I know maybe in differential privacy, it could be easier to have these numbers with the epsilon and so, however, setting the epsilon is harder, of course. But for other bits, let's say, in general, is there a unified way to have this?
So I should say, as the head policy, not one of the technical experts, I don't want to roam into speaking about leading research at this point in time because I'll get it wrong. But I would say that the ways in which we think, so often privacy is trying to follow what security did 20 years ago. And so security got better at comparing systems by having security goals, the CIA triad, confidentiality, integrity, availability. And you could describe a system and under which parameters you maintained those properties against what kinds of attack. And there's a lot of work in the privacy field to do the same for privacy, that you should still be preserving those 3, but adding, and the things that get proposed are predictability, disassociability, and manageability, a NISTs. And a NISA has 3 as well, unlinkability, transparency, and intervenability. But those are things that you could test a system against as to under what conditions they held those. I think that may be a way of doing something like what you're describing. Yeah. But actually some of the other things that we see coming in are things like overhead costs, exactly. Complexity, those things are actually drivers then of which pet to use in which situation.
Indeed, yeah, because at the end, you will end up, for example, of set of bits that may apply in your case, for example. Each of them has different complexity, provide different privacy, so you have to make the trade-off, the decision at the end.
And simpler is better. When you can be simpler, it's huge advantages for so many reasons, like speaking to regulators about it all.
Exactly. So I think,
and that comes back to use cases and so forth as well, best practice
of course,
in certain contexts.
Yeah.
If I add a sentence when no one said, a lot of pets are heavily energy intensive and heavily carbon intensive.
Absolutely.
And that's an important thing to bear in mind too.
Thank you very much.
Hello. I was going to follow up on that use case idea. it has the risk of becoming a cargo cult thing. So somebody else used this pet like this, so apparently this is fine. So as far as I know, no data protection agent will say that a pet satisfies something. It might say that if you'd use this pattern, there is a better chance that you satisfy a legal requirement. But you always have to look at the solution, not just the technology, a combination of tech and process. So I would say that while these use cases are great at communicating the capability of pets, use it myself all the time, then you have to redo almost every case. I haven't yet seen how can this be replicated at all times. And the second point was just regarding measurement. One idea is to have a nice table of stakeholder times data object, and then in every cell you put a probability that this stakeholder can re-identify a person from this data object, and that's a nice comparison measurement. That's a response to one of the previous ones.
Can I just add? Sorry, you have to be rather tall. I'm the Chief Technical Advisor to the Investigatory Powers Commission, and in that capacity I convened a little workshop on measuring privacy, because the job is to make sure that any investigatory activity minimizes intrusion privacy. And so the answer to the previous questioner's question is no, there is no. As a mathematician, I said, well, if you're trying to minimize something, you have to measure it. That's what mathematicians like to feel. But sadly, talking to a lot of people in the field, I get to the conclusion that there is no single measure of privacy. And we just have to, maybe later on, we can discern a measure of privacy by seeing what people. If you think that A is better than B and B is better than C and so on, eventually you can actually infer a scale, but we're a long way away from that.
About the use cases quickly, and also one other point. I don't think, at least from my view, the idea of a use case is not to say this meets this legal criteria, although some DPAs have done this really problematically. The Estonian DPA has done this before for a case that I really do not believe is out of data protection. And the Bavarian DPA for the private sector did it in quite a controversial case that I saw before around facial recognition or facial analysis. So there are times that it's sort of happening on the fringes, which I think that's a bit uncomfortable. But the use case idea is to really say, what kind of processing are you doing? Your processing is set up in this way, is with 2 actors or 3 actors, or it's inside your organization, and you're doing it this way. However, we've got other controllers that do this without using data, or they actually achieve this same aim without using this data. Therefore, it is unclear whether you really meet the necessity test, because it's unclear whether there's necessity going on here. And of course, you don't want to put it at the very, very cutting edge, because you're not trying to force every controller into very experimental territory. But the idea being, when something becomes a practice where it's quite clear that it can be done better, then that's important to think about, particularly because of the reuse of data and the establishment of an application of new purposes and new lawful bases to the same data sets after they've been transferred, which creates really big problems of function creep. And if you can avoid that, then I think that's a big win.
I would also like to address the case of use cases. So in our role play, we took the example of HR, and we also tried to make you think about that just because a solution worked for someone else, it doesn't mean that it also works in your case. But of course, there are many processing activities that are very similar across many companies, and HR, I think, can be one of them. And maybe there's still room for some use cases for very standardized processing activities where the actual needs deviate very little, and then indeed solution can be easily transferred from one company to another when the processing is so similar. And we already see nowadays that many companies actually use the same tools and the same methods for their processing. So the answer is, yeah, it can be useful for some situations that are very, very similar usually, and it can be very dangerous if people deviate from what other people are doing.
Yeah, just to follow up on that, so I think there are examples where you get particularly close alignment. For instance, things like suspicious activity reports in banking, where there's a certain thing that you're submitting to the regulator, and supposedly one should be looking at certain risk factors. And if you're adding information, a lot of the banks may be looking at similar sources or doing similar things in order to generate their risk score for that report. And so those are the kind of things where I would hope maybe there's some consistency between what banks are doing in one situation and another.
So we've got time for one or two more questions. Thank you.
You go for it? Okay. Hi, my name is Paula Bielski. I'm a sociologist who studies software developers in practice, and I loved this little role play here. It was really cool, but also, of course, as a sociologist, I say things are a little bit more complicated, and I think it's a really nice metaphor you had in front of us here, because it's not just, a compliancy officer who comes and says, what are you guys doing here? And then someone from the team says, yes, we're really working on a certain pet and it's working well. I mean, in general, we know that software is developed by a team, and it's not enough, like we say maybe to a surgeon, say, make sure your whole surgery team washes their hands and then everything will work out. There's so many moving parts when you build a piece of software that for me it's always, and someone who's been following kind of the world of pets and how it's being implemented, it's a best practice, but I always try to figure out what goes beyond this best practice. This is not how it works, and because there's so many moving parts, how do we really make sure that everything is compliant? And we don't. So I just still don't understand how pets goes beyond something robust and not just a best practice, I guess, when we think about stuff actually on the ground level and how it's being done. Yeah. So that's maybe my question.
Yeah, we'll take both questions together and then reflect on final thoughts.
Thank you for the interesting presentation. I am Nazan Gifani, working as a DPO for a Belgian tech company as well. And my question is more about how you can raise awareness for SMEs, because big multinational companies usually have access to at least the money to apply these technologies, especially state-of-the-art. But if the bar is so high for SMEs, it becomes more and more difficult, and especially because there is always a race for optimization and being fast and agile. So it is in practice comes to maybe few checkboxes, and also you have to consider that the people who apply machine learning, they are not security expert, they don't have the toolbox, and even data protection officers, they don't have the full toolbox of assessing what these technologies do. So what is missing maybe is a more ready to use kind of guidelines, or I don't know, I'm more interested to hear your point, how it can become more a prevalent practice for smaller players who don't have the resources as bigger players.
So I might ask each of the panel members to reflect on the last two questions, as well as give some final thoughts, maybe about 30 seconds each. So Robert.
I see things are in practice much more complicated, and the complexity of the matter is exactly what I wanted to address. And there must be a way to boil that down, to have a structure on how to approach that. And it is in particular not the data protection authorities who are in demand to figure out how the complex setup and companies work. The GDPR demands to demonstrate, demands controllers to demonstrate that. And it is of course an open question. So that to that question. And indeed, we need to support small and medium enterprises. I hope that there will be at some point a knowledge database, maybe provided by a government body, or maybe by an international body even, or a researcher community, research body, so that there's an overview what is available. So this could be shared among those actors that do not have the access to their own development team or own research team.
I got 30 seconds. I'll be very brief on actually talking at SME. I think bigger companies can have a role in this. So, for example, Mastercard worked with Irish Data Protection Authority to have workshop for SMEs, kind of some of the techniques that we can share. I actually often go to many customer sites as well to share what we do without giving them legal advice, but we do that. So that's one way. Another thing is we have a program called Start Path. So we have all the startups that have a very great idea, great technologies, but perhaps not so mature on the culture of how we deal with the data. So that's where we can support them through not just giving funding or investing, but also we do share experiences. So there are, I think, various ways that actually big companies can help as well.
So I think at such a high level, maybe this will be a trivialism, but essentially pets give you more options, right? So in the past, if it was binary, have data, don't have data, there are more options with pets. You can control what someone can learn or see or do with data, and whether sharing is required. Just because you have more options, that doesn't mean that having those options automatically means you're doing the right thing or a compliant thing. And also it adds complexity. And I think that is a challenge for SMEs. I think that is a challenge for SMEs. I think in terms of the other element to the question, it really comes down to the use case. I think you have those options for these new tools to use. That it will become very fitted to what is appropriate for any given time, for any given context, and that will depend on things like the purpose and the data itself and the parties involved.
I enjoyed the remark about sociology of compliance. I think that's really important. One thing that I would add is that in my experience, and we've written about this a bit with some colleagues, you can see pets, or maybe you can say pet washing, fake pets being used to deny individuals data rights, particularly rights of access, right to object, right to erasure. Effectively, we can't find your data, but a hacker probably could if they were in our system. Apple have done this notoriously with the Siri data by effectively not really applying a pet, just saying everything's indexed to a device-specific ID and it's on our database. Our database is a bit hard to get things out of. We haven't built a system to get it out of it yet. And also, the device-specific ID is just not available in your menu, and we don't have any way to verify it on your device. So good luck, we won't provide the data as a result. Not actually a pet. They will describe it as privacy by design, and have done, and deny access rights on that basis. But it's hard to assess in that context for a regulator to say, where does it fall? How do we assess? Thanks.
Great. Thanks, Phil. So it seems that pets can or may have a role to play, but they're certainly not the answer in and of itself. Context matters, incentive matters, there's much complexity, so let's all watch this space. Can we all please thank the panel? And thank you for your time and attention.